Hello, everybody. Here we are on my live. Remember, I'm not just Facebook Live anymore. I am now YouTube Live. Yay! Hopefully, you're watching from either media center or media outlet. But here we are. It's November 30th. Hopefully, you all have recovered from your Thanksgiving Day feast. Those of you in the United States who celebrate Thanksgiving. I know I did. I didn't eat a lot, and I just want to let you know why. Now, those of you who know me or don't know me, I am vegan. So Thanksgiving is kind of a challenge for people's that I go to. When I go to their house, they're like, we didn't know what to make. One person asked me where they could find a tofu turkey. I said, I don't know where you can find a tofu turkey, but I'm not eating a tofu turkey. So don't get a tofu turkey for me. I don't even know. I can't even imagine what that is. Is it tofu shaped like a turkey? I have no idea. Anyway, I want to welcome everybody. And again, hope you had a blessed and quiet Thanksgiving. We needed something quiet here in Florida as we've been, bombarded by hurricanes lately. And so we just needed time to just kind of recover and relax from that. So I hope you had a nice time with your family and your friends and, were able to watch all the games that were on, which reminds me. Yes, I have now realized that my live is going at the same time that Argentina is playing in the World Cup. So, for those of you who are watching me and not watching the game, thank you. For those of you who are watching me and watching the game, thank you. Those of you just watching the game, go Argentina, right? But anyway, I don't mean to interrupt anybody's World Cup games. They are very exciting. I enjoy watching them as well. I'm becoming more and more familiar with what we call here in the United States soccer, what in other countries they call football. So I enjoy both American football and soccer. I'm getting to enjoy them both. So, anyway, here we are, my live, right? And what is our topic on live today? My topic on live today is going to be like all the videos I've had throughout the month is usually I focus on one crime, but I thought, yeah, no, that doesn't really kind of sum it up. That just, kind of just cornhole or put it in a little ball, just one crime. But a lot of people ask me questions about the procedures and what does that mean and what does this mean? So that's why I thought it would be a good idea this month, especially with the holidays, because holidays tend to be parties and drinking and people drink a little too much and maybe they get into an argument or maybe they drink and drive or whatever. They get arrested and they don't know what's going on. They don't know what the procedure is. And so that's why I thought it would be a good idea to kind of go through the procedural aspect of it, because that way, the general public becomes more familiar with it. Hi, Ariana. Good afternoon to you. I like your orange. You just pop right out in that photo. I think that that's a nice color. I was in Mexico recently and I was doing some shopping and I saw this bright orange full length coat. I put it on. Yeah, color's not for me. I don't know if you notice a lot in my videos. I'm mostly black, gray, navy. If you see me in a bright color, maybe it's laundry day. I didn't have anything else to wear, but you're not generally going to be see me in those bright colors. But I like them on other people. It's just not for me. But anyway, it looks beautiful on you. So, hi, Augustina. Good afternoon. Wow, what an interesting picture. Very nice. Talking about color, right? I think you guys are trying to tell me something. Hi, Michael. Good afternoon to you too. I'm glad that everybody is coming in and maybe, like I said, one eye's on the World Cup and one eye is on me. Hi, William. How are you doing? Now remember last live that I had a special guest. No guest today. All you have is me. Well, I'm a guest, but you all are really the center because I'm here to answer your questions. So I'm really not alone, am I? I have you there to ask questions, to participate, to talk to, just to kind of relax and talk about things. So that means since I don't have a special guest today, that my other special guest is back. Remember, I told you that newscaster Laura that she was off somewhere. She was in some tropical area. Yeah, that's where she was. So she didn't newscast last time. But this time she is going to newscast because she's going to talk about a couple new laws that we have here in Florida. Not new laws, but just enhancements to current laws that we have. And so she's going to be newscasting. Then, she's going to throw it back to me so that I can talk to you about the videos and give you more detail of what we talked about this month. So I think we're ready. We're about 6-7 minutes in. Hopefully y'all are settled back. You got your popcorn, you get your water or your soda or your tea, whatever you're going to be drinking. And you're going to be cheering on Argentina on one end and talking to me on the others. Thank you so much for joining me. And again, if you have questions, please pop them up. I'm going to answer them as we go along, and it helps me kind of take a breath. Hey, Anna, how are you? What a pretty picture. Nice little slant. Hi, Paula, how are you? I'm so glad everybody's joining us. So if you remember my videos, remember my first topic that I spoke about, which is always a hot topic. Clients always ask me about this when they come in. Your Miranda warnings. Here in the United States, we have Miranda warnings. And what are those warnings? We all know them here in the US. We've heard them on television. We've read them in the newspaper. We've read them on social media. Everybody talks about your Miranda warnings. And what are your Miranda warnings? Let me tell you what they are. What they say is you have the right to remain silent. You do not have to talk to the police. Anything you say can be used against you in court. So if you decide to talk, anything you say after that point can be used against you in court. So you got to watch what you say. You have the right to talk to an attorney for advice before we ask you any questions. So if you say, listen, I don't want to answer these until I talk to my lawyer, the interview stops. You have the right to have a lawyer with you during questioning. So, you see on Law and Order, I love Law and Order. I love Law and Order Special Victims Unit. That's my favorite one. It's on at like 4:30 in the morning because that's what time I get up. And they're, whatever her name is, Mariska Hargitay, I can't remember what her name is on the show, but she'll be interrogating and then they'll say, I want a lawyer. Boop, they have to stop. Of course, it's kind of, what I want to say, kind of made pretty on TV, but where did these Miranda warnings come from? Did somebody just make them up one day? No. What it was is the U.S. Supreme Court in 1966 made a decision in Miranda versus Arizona. So Miranda was saying, hey, I didn't know that I had the right. I should have been told that I had the right to remain silent. And so the United States Supreme Court agreed with that, and that's where these Mirandas came from. And so what Miranda versus Arizona created is it's to protect an arrested suspect, in custody suspect's constitutional right against compelled self-incrimination. You'll hear in court hearings, the judge will say to the defendant, for example, Casey Anthony, I don't know if you remember that, that's here in Florida. They asked her when it was the defense's time to put on their case, Miss Anthony, do you want to testify? Understand that anything you say, can be used. Also, they cannot use your right to remain silent against you. And so you're asked that, do you want to testify or not? No, I do not want to testify. You can't be compelled to testify, just like you can't be compelled to talk to the police if you have been arrested. Remember that, arrested. If you've been arrested, they need to, first of all, read you your Mirandas. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before you ask any questions. You have the right to have a lawyer with you during questioning. Do you waive those? If you waive them, if you say, yes, I waive them, I want to talk, guess what? Everything you say can be used against you. Now, you may think, well, I'm not saying anything incriminating, but you don't know that. You don't know that. And so you can say, I don't want to talk. I want to speak to an attorney, and the interview needs to stop. So I always get questions. Oh, Anna, hold on to that question for a second. I always get questions. Well, I was arrested, but the police didn't read me my Mirandas, and so they were in violation of my Miranda rights. I said, well, did you say anything? Did you, say anything incriminating? Did you say no, but they just didn't read me my rights? Well, if you didn't say anything incriminating, then it's no harm, no foul, because then it would be difficult to what am I going to court to quash? I have nothing to quash because you didn't say anything incriminating. So if you didn't say anything, then no harm, no foul. So, but they are to read you your Mirandas. They should. It would be good practice for them to read it in the event that you somehow blurt something out or say something that you didn't mean to say. They at least have read you your Mirandas, so they should read those. So I'm sorry, Anna, why don't let me see your question again. Just I didn't want to lose my train of thought. I teach at the university and I'm always like, hold that thought so I can get my thought out. Miss Laura, can the police detain a person without reading their Miranda rights? Well, like I said, they can arrest you. And if they don't read you your Mirandas and you don't say anything incriminating, then okay. But it would be good practice for them to do it. They need to do it every time because like I said, let's say you're in the back of the police car. You've been detained, you're arrested, you're heading to the police station, and they haven't read you your Mirandas. They have not. And you suddenly say, oh my gosh, I left my knife at home, or whatever you say that may be incriminating. That could be quashed because you weren't read your Mirandas and you spontaneously just said something that incriminated you. So it's always a good idea. And understand that if English is not your primary language and the police are only speak English, like me, I only speak English. If I was a police officer and your primary language was not English, maybe it's Spanish, and I'm reading you your Mirandas and you don't 100% understand those Mirandas, you need to have an interpreter. Do not have an interpreter of your friend, your cousin, your uncle's John, your Aunt Susie. Make sure that the police provide an interpreter, because I've had cases where Uncle Jimmy, cousin Timmy, nephew John have been the interpreter. They're not doing it correctly, or maybe they're not interpreting correctly. And you have a problem then because you're saying you understand, they believe you understand, and then you start saying things. So that may be it may still give me the option to do a motion to quash, but it still gives me what I want to say, a difficult road to hoe. So very good question, Anna. Thank you for that question. So after you read your Mirandas, thank you, Mercedes. After you read your Mirandas, then the police, like I said, they'll ask you, do you waive? Do you understand these rights? Are you willing to waive them? Don't say you understand them unless you understand them. If you don't understand them, maybe you need an interpreter. Maybe you need them explained a little bit better, but make sure that you understand them. And if you're willing to waive, which I would not advise, but if you're willing, then you waive. But again, I don't advise that. If the suspect waives them and agrees to talk, everything he tells law enforcement is admissible against him in court. If he asserts his rights and declines to waive them, the officers are required to terminate the interview. So if you're been arrested, you're being interrogated, you see Law and Order, they're being interrogated, and you say, I want a police officer, I want to remain silent, they need to terminate at that moment. They cannot be like, well, are you sure you want an attorney? Oh, that's going to make this so complicated. No, they need to stop it. They're not there to convince you to not have an attorney present. So they need to terminate, and then you can do what you do from there. I have turned in clients before to the police when they've wanted to be turned in, and I go with them, and I will actually go back with him to the interrogation room, and I will tell the police officers myself, my client does not waive his Mirandas. He will not talk to anybody. He's not going to make a statement. He will not make any statements unless I'm present. So I instruct them, they're not talking. So Anyway, so that's Mirandas. Mirandas are always a hot topic. I had a classmate in law school. He was a riot. He had a T-shirt actually that had the Miranda warnings on the front of them. I always got a kick out of that when he wore them. I always thought, I go, oh, where can I get a T-shirt like that? I like that. Anyway, okay. So you've been arrested. You have not waived your Miranda rights. You say, hey, I want to remain silent. I want to talk to an attorney. Boom. The interview is stopped. You're in custody. Now, let's say we've got different crimes in the state of Florida. So we have these degrees of crime in Florida, and what is their maximum punishments? So Florida has, first of all, we have felonies. Felonies are the higher crime. There's 5 degrees of felonies. There's felony in the 3rd degree, which is the lowest. The felony in the 2nd degree, which is the next step up. I look at it as steps. Think of it 5 steps. So I've just stepped on the bottom step. That's a 3rd degree felony. Now I step on the 2nd step. That's a 2nd degree felony. Now I step on the 3rd step. That's a 1st degree felony. So you're like, well, okay, well, but that's 3 felonies. What about the other 2? Well, we have here in the state of Florida, we also have a life felony and a capital felony. So let me tell you what the maximum punishment is. The maximum punishment is if you go to trial and you're found guilty, the judge can give you these maximum. Now, here in the state of Florida, we also have minimum mandatory stuff like that, but I'm not going to get into that. That can just make your mind explode. So anyway, our first step, our 3rd degree felony, the lowest, the first step, it's punishable by no more than 5 years in prison and a $5,000 fine. Again, you go to trial, you're found guilty, the judge can give you no more than 5 years in prison. And you spend prison time anytime you spend more than 365 days, or you're sentenced to more than 365. So if you're sentenced to 365 in a day, you go to prison. If you're sentenced to 364, 365, you stay in the jail, like the Orange County Jail or Seminole County Jail. If you add more than that, then you go to the Department of Corrections. So anyway, so 3rd degree felony, maximum 5 years and a $5,000 fine. The 2nd degree, I do my 2nd step up the ladder or up the steps. Maximum punishment or maximum exposure, what I like to say to my clients, is 15 years in prison and a $10,000 fine. So you can see it's kind of getting worse as you go up the ladder or up the steps. So, and remember, 2nd degree, that's the 2nd step. That's the 2nd highest. Felonies in the 1st degree. So you're going up the 3rd step. So that's the 3rd highest, is felonies in the 1st degree are punishable up to 30 years in prison and a $10,000 fine. So you see how all of these things are getting worse and worse. Now, we have life felonies. What that is, and what we call it here in the state of Florida, is punishable by life. We call it a PBL, punishable by life. This charge is punishable by life. So a life felony is punishable by up to 40 years in prison and a $15,000 fine. So, and then last but not least, here in Florida, we have something called a capital felony. A capital felony would include capital murder. That would mean it was 1st degree murder. There was contemplation. There was a murder involved. Felony murder, meaning a felony was committed at the same time as a death. So let's say the person goes in to burglarize the home as a felony, and then somebody dies in the process. It could even be your co-defendant. We had an issue here one time. We used to have those, I don't know, gambling areas. I don't know. They would go, I never really knew what it was, but they would go in, people would go in, they'd be open 24 hours a day, and they could go to these machines and do gambling or something. Anyway, it was in the middle of the night. It was in my neighborhood, if you can believe that, just a mile down the road. And these 2 men went in to rob the place. Well, little did they know there was a security guy with a gun. So these men went in, pulled guns, all of that. Well, the security guy shot at both of them. One of the co-defendants was hit by the security guy and he was killed. He subsequently, he didn't die right there. He died later on, but his co-defendant was charged with felony murder because they were committing a felony. They were going to burglarize or rob this place of business, and in the commission of that felony, somebody died. It could be the co-defendant, it could be your victim, whomever. That could be a capital felony. So just depending. Anyway, so the capital felony is punishable by death. We have the death penalty here in Florida. Your state may or may not. Punishable by death or life imprisonment. Here in the state of Florida, life imprisonment means life. There's no parole. There's no gain time with life. Life is life. You do not leave that prison until you subsequently pass away. So that's what a capital felony could be. It's either, death or life imprisonment without the possibility. The only thing that we call capital that may or may not, that death would not be an option is capital sexual battery on a child under the age of 12. That does not have the death penalty, but that does have a life imprisonment, a PBL, punishable by life. So anyway, so those are the degrees of felonies. So let's drop it down a little. Let's get to something a little less serious. Misdemeanors. Misdemeanors are a lower level of crime here in Florida. Driving without a license, DUI if it's your first offense and you haven't been habitualized. Let me see. There's also trespassing, anything like that. That's a misdemeanor, maybe a petty theft. There's two kinds of degrees of misdemeanors, just two. So the lesser one, so I'm going back down my steps and I'm going to the other steps because there's only two in a misdemeanor. My first step is a second degree misdemeanor. Second degree. That's again, if you went to trial, you're found guilty, the maximum punishment you could get is 60 days in jail. Because that's 60 days. So you only have to spend it in the county jail. 60 days in jail or 6 months of probation and up to $500 in fines. So that's a second degree misdemeanor. A first degree misdemeanor, we're taking a step up. We're now up a step, is punishable by up to 12 months, up to 12 months in jail, 1 year of jail, potentially 12 months of 12 months of probation, and up to $1,000 fine. Those kind of misdemeanors are anything from like cruelty to animals, maybe possession of some drugs, like less than 20 grams of marijuana, and a battery, like a domestic violence. So that's a first degree misdemeanor. A second degree, the lower step, 60 days in jail and up to $500 in fines. The next step is up to a year in jail and $1,000 fine. So those are the degrees of crimes that we have in Florida. Every state is different. Everything is different. So, but this is how we do it in Florida. Okay. So you've been arrested. You are being potentially charged with a crime. So what happens? Do you just sit in jail and just twiddle your thumbs until somebody makes a decision about what to do with you? No, we have hearings. And in criminal court, things move pretty quickly. And we'll explain that towards the end of why. They move pretty quickly because people have a constitutional right to not sit in jail or not sit and have these charges hanging over their head without knowing anything. So we have hearings. So let me take a second so I can deal with Florencia. Well, you can put back up Florencia. Can someone sentenced to life in prison be released sometime earlier for any reason? No. If they're sentenced to life in prison, it's life in prison here in the state of Florida. Now, if some new law came about, we had something recently, it was quite a few years back, about death penalty, that the juries here in Florida, we do the criminal phase, the trial, then we do the sentencing phase when it comes to, death or life. And so the jury decides whether or not, if they've been found guilty of a life felony or a capital felony, they decide guilt or innocence. And then they have a separate sentencing hearing where the jury decides life or death, if death is on the table, if death is truly out there. So years ago, it used to be the jury didn't have to be unanimous on a death sentence. It could be, there's 12 jurors, 10 of them could say death and 2 could say life in prison. And because 10, which is a majority, voted for death, then they got the death penalty. Well, new law came about that said, we need to have everybody. We need to have a unanimous jury. So there are people actually coming back that are having to be resentenced because the law went retroactive. And so a bunch of people are having to come back to see, okay, if they have the death penalty, are they now going to life, or are we going to do a resentencing hearing? So, it's caused a lot of kind of chaos, really. I have a friend who's having to go through that, but not as an attorney. He's having to defend somebody. Not that I have a friend that's going to be put to death. But anyway, unless something changes with the law like that, as far as their crime or the punishment or whatever, life is life. And so, they spend the rest of their lives in prison. So good question, Florencia. So criminal hearings. So the stages of hearings we have here in criminal court here in Florida. You're arrested and you're sitting in jail. You're entitled to a first appearance within 24 hours of being arrested. Now, some can just post a bond and leave. They don't need to attend first appearance, but some people do. For example, battery domestic violence here in Florida. They make you sit there and go to first appearance. Why? They want you to cool down. They want you, both parties to so they make you sit there and go to first appearance. So there's, a whole barrage of people that could go to first appearance. And so first appearance is just saying, hey, is there a bond? What are the charges that are going to be filed? Do you want a lawyer appointed for you? Are you going to pay for your own attorney? That's all really a first appearance is. And then if there's a bond, can they post the bond and they'll go off and deal with that. But that's really what a first appearance is. Pretty quick. So after that, after the first appearance, you're set for what we call an arraignment or a preliminary hearing. So an arraignment is, most of the time, what we do as attorneys, we just waive your appearance and we waive our appearance, because really at the arraignment, it's really just saying, okay, what are they being charged with? Is there probable cause to go forward? And maybe it's dismissed. Maybe there's an offer thrown out to the defendant and they want to accept it. I advise not to do that because you never know what us as attorneys can do for you. But, that's up to the person going. I've gone to arraignments before and I've watched them and been like, oh, I wish they wouldn't accept it, because you never know. You never know what could happen. What's your case about until you get in front of an attorney. But that's everybody's choice. So the arraignment goes on. Usually, like I said, we waive it. We do a notice of appearance, a waiver of arraignment, meaning nobody needs to go, a request for discovery, which is a request for the evidence in the case. We want a copy of everything in the case. We want any videos, body cam, pictures, police reports, witness statements, whatever you have, the state has to give to us. So we're requesting that discovery. A plea of not guilty. We're just saying you're not guilty. Just put that out there. And a request for a jury trial. Now, that doesn't necessarily mean we're going to go to a jury trial, but at least we've pled that. So that's really what we do. And we just really don't go to arraignments. So after arraignment, then it's set for either a pretrial conference, a case management conference, whatever it may be. That is so the case can be kept moving forward. The court wants to know what's going on. They don't like with a divorce. A divorce can drag on for 3 years. I actually had a divorce that did drag on for 3 years. I just want to point out. They don't like that in criminal cases, unless it's a big felony, and there's a lot that has to be involved. But they don't really like that. They want these cases to move. And if they're not moving, why are they not moving? What are we doing? Are we doing depositions? Are we doing motions? What are we doing? The court wants to keep track of what's going on so that the cases move and don't become stagnant. Because what happens when a case becomes stagnant, when it becomes old, the evidence gets old, witnesses' memories get kind of fuzzy. So they want to keep it moving. So they're constantly having these hearings. So they usually schedule them on a monthly basis. I'm constantly getting dates for criminal hearings. We either ask for continuance based on, X, Y, and Z. Um, Maybe we'll ask for a 2 docket continuance, meaning, hey, we need more than a month. We need 2 months. We got to give a reason. What's the reason for doing that, for requesting that? So a lot kind of goes on. It's mostly a cattle call. Everybody shows up for all their cases that are for that day. And then they ask the judge, hey, Your Honor, we're asking for a continuance. We have depositions scheduled in this case for January 6th. And generally the state will agree and it's continued to, and they're giving you a new date. So also, there's trial as well. So trial is the end all be all. If you're not going to accept a plea offer from the state, you don't like the plea offer, you want to take it to trial, then there's trial. And as you know, trial, we see him on TV. I was just watching on TikTok that Brooks trial, the one where he represented himself in Wisconsin. He's the one that drove through the parade or whatever. Oh, I just kept scratching my head. I would advise everyone and anyone, never represent yourself in a criminal. Well, never represent yourself in a legal matter because you don't know the law unless you're an attorney. You don't. And watching him and, asking about subject matter jurisdiction and all, he just didn't know what he was doing. Maybe it would have turned out better for him. I don't know if he had an attorney. I really can't say. But you should always have an attorney with you because we know the law, we know what to talk about. But Ariana, if I have to move from Florida, what should I do about my child custody? Well, we're really not talking about family issues today. We're talking about criminal. But if you have a case in Florida and you want to move, and especially child custody, please feel free to give our office a call. We'd be more than happy to talk to you about that because there's some issues there that we may need to bring up. And what we're talking about today is criminal. So I hate to kind of muddy the water, but please, Ariana, give us a call and we'll be able to talk about it with you. So thank you so much for bringing that up. Hello, Marcos. What is the correct order of procedure during a criminal trial? Well, if you're talking about who goes first, who goes second, who goes last, here in Florida, it's always the burden of the state to prove the guilt of the defendant. My clients always want to say, well, I want to say what I did, blah, blah. No. It's not your job to prove your innocence. It's not that. It's the state's job to prove your guilt. So the state always puts on their case first, their evidence, their witnesses. Of course, the defense can come and cross-examine their witnesses and all of that, but it's always the state that goes first. Then when the state rests, then it's the opportunity for the defense to go. Now the defense can call witnesses or they cannot call witnesses. They can ask the judge to dismiss the case after the state has rested, saying the state has not proven their case beyond a reasonable doubt. I haven't done that in a criminal trial. I've done that in injunction trials where the petitioner has gone first in trying to prove why they need a protective injunction because they're in so fear for their life. And then when they rest, then it comes to me and I'll stand and say they haven't met their burden. I ask that the court dismiss this petition because they haven't met their burden of proof. And then it's up to the judge whether or not he's going to grant that. But it's always a good idea for an attorney to put that on record for appellate purposes. But if the judge doesn't dismiss a criminal case, then the defense can put on their case to try to establish reasonable doubt, because that's what the defense wants to do, is create doubt in the mind of the jurors, because the standard in a criminal case is beyond any reasonable doubt, So let's say it's a murder trial and my defendant is being charged with murder and my defense is a clown did it. Bozo the clown came to the house. Is that beyond a reasonable doubt? Maybe, depending on what the evidence is, but if there's no evidence, is that beyond a reasonable doubt? That's really going to be up to a jury. So they put on theirs. Well, first there's opening, then there's the state puts on theirs, they close, and the defense if they choose to, and they don't have to put on a defense. puts on their case, and then they have closing arguments, and then jury instructions, and then the jury goes off into the jury room and decides, and then hopefully they come back with a verdict. Or they could be a hung jury where they can't decide. They just can't, or they can't come up with unanimous. Maybe they have 11 jurors that say guilty and one that says not guilty. They have to be unanimous. They have to be. They have to be. They can't come back and say, well, we all say it's guilty, but he doesn't matter. No, he does matter, because that one not guilty. So they have to come back if they cannot come up with a verdict and say it's a hung jury. And, at that point, the jury is dismissed and the state has to decide whether or not they're going to do another trial, or they're just going to offer something, or what they're going to do. That would be up to the state to decide what they're going to do. So very good question, Marcos. Okay, last but certainly not least, speedy trial. I know it's a tricky one. You think speedy trial, that your trial should go fast, right? When it starts, it should go fast under speedy. Some of these trials can take weeks, which is crazy. I mean, I couldn't imagine I had one that dragged on for 3 years, and we did have a 4-day trial, but it was 2 days. And then a year went by because a bunch of stuff was done. And then we had another 2 days. So at least I had that break, but I couldn't imagine a couple weeks or 3 or 4 weeks that some of these criminal trials take. But anyway, what speedy trial is every person charged with a crime shall be brought to trial within a reasonable amount of time. So what is a reasonable amount of time? Well, of course, the Florida legislature has put down time limits. So for a misdemeanor, you have to be brought to trial within 90 days of your arrest, if it's a misdemeanor. So from when you're arrested, or from when you receive a notice to appear in lieu of a physical arrest. Maybe you weren't arrested at the time, but then later on, the state attorney decided to file charges, and you were served, or you were sent a notice to appear. That's when the clock starts ticking. So 90 days. So what we do sometimes, or most of the time, is if you request a continuance, you got to waive speedy. You got to stop the clock. You got to stop it. Hey, we're not ready yet. We want a continuance. We waive speedy. We waive the right to be brought to trial within 90 days, because sometimes 90 days is not enough. So if it's a felony, 175 days from the time of arrest or the notice to appear. The clock starts ticking, tick, 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 to that 175 days. Again, if you ask for a continuance, if you need more time, you do a motion to continue, you waive your client's right to speedy, and so the clock stops for you to have time, because some of these, like I said, murder cases, all of those take a while, and 175 days is definitely not enough time, at least in my opinion. But hey, there's attorneys, wonder attorneys out there, so I give them credit. If speedy has not been waived, if we don't say, okay, we waive speedy, we want the clock to stop. If it's not been waived, and it doesn't go to trial in that 90 days or that 175 days, then the result is that a time extension. Well, first the court has to look at it. The defendant would file something saying, hey, trial hasn't happened. I never waived my speedy. Then the court has to decide, okay, has a time extension been ordered? Has the failure to hold the trial been the fault of the defendant or co-defendant? Anybody that caused it on the defense side. Or maybe the defendant was unavailable. Maybe they had some medical event and were in the hospital. So the court has to look at that. And then if they decide that, hey, it's no fault of the defendant, there was never a time extension, the defense was always ready to go to trial, then they could say, hey, we're dismissing the charges, or something else like that. So we want to make sure that we keep track of those days, and we do. If we haven't waived speedy, that we keep track of those days so we can go to court and say, hey, they weren't brought to court. We want a remedy on this. They shouldn't have to have these charges held over their head. And again, that's why we keep these cases moving. Now, Anyway, Jimena. Oh, I like your name. What happens if I'm charged with a crime in Florida but live in another state? Let's say you were in Florida for spring break. Yay, you're having a good time in Miami Beach. Woo, 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 woo. You're drinking, you're having a good time. You drive, you're arrested for a DUI. But you're, or maybe you weren't arrested. Well, let's just say you were arrested. You were arrested for a DUI. You went out on bond, of course, and then you have to return to Georgia, where you're from. Of course, you have to let your bonds person know if you used a bond person or if you did a cash. You still have to, what do I want to say, answer to those charges in Florida. I have so many clients that say, well, can I move this case to Texas where I'm from? That'd be more convenient. No, you can't. Wherever the crime happened is who has jurisdiction. So Florida, let's say it's Miami-Dade County. You were driving, you didn't have a driver's license. So they just issued you a notice to appear and you got a ride back to Georgia. You cannot have that case transferred to Georgia. You have to answer it in Florida. So it's so inconvenient. I know, but that's how it is. That's who had jurisdiction. That's where the witnesses are. That's where the evidence is. That's why they have to keep it in Florida. So your best bet is to maybe hire an attorney to take care of that case for you. What we do a lot of times is a PIA, plea in absentia. So, hey, if you agree, hey, I don't want to go to trial. I just want to take the offer the state's giving. What can I do? We can do a plea in absentia where you sign a plea form. We send it to the court. Everybody signs it. And now you abide by whatever that is. Maybe it's just paying a fine. Or see how we're talking now? Courts now have gone not 100% virtual, but you can get virtual if you live out of state. We can file a motion requesting that you appear virtually, that we appear virtually with you, whatever it may be. Because I have a lot of people that not necessarily like you live out of state, but live in the state, but maybe they were caught in Tallahassee with a no valid driver's license, but they live in Miami-Dade. That's quite a trek, right? So what we can do is either, like I said, a plea in absentia or have you appear virtually. So that's how we've gone forward now here in the United States, as I'm sure it's not just here in Florida that we can appear virtually. So very good question though, because I get that a lot from my clients that have, have been driving through Florida or here on vacation. I had one that took his family to Disney, but unfortunately he didn't have a valid driver's license and was caught up in the panhandle returning to Texas. And so we're trying to deal with that case right now. So it can be kind of tough. So very good question. Thank you so much for asking that. Anyway, let me kind of talk about speedy trial again. If you've waived speedy and now you're like, I'm ready to go. I'm ready to go. And you want to demand speedy, meaning you want to bring it before the court to do a trial. I've done that one time. I had a client that we had waived speedy. And so the only witness of the state was in jail up in a different county on a gun charge. I went, ooh, hot dang. That's good because the state probably is not going to be ready because their key witness is in jail. So I did a demand for speedy. I did what we call as a demand for speedy. And so you file with the court and within no later than 5 days from filing of the demand for speedy, the court needs to hold a calendar call, meaning everybody's got to come. The state's got to come. The defense attorney's got to come. The defendant's got to come to court and express the purposes and announcing in open court the receipt that the court received the demand and they're setting the case for trial. So, and the trial commence at a date no less than 5 days and no more than 45 days from the date of the calendar call. So the failure of the court to hold that calendar call on a demand that has been properly filed and served on the state could run that period. And the defendant's not been brought to trial within 50 days of the filing of the demand. Again, you bring forward to the court saying, hey, I did a demand. I did everything right. We had the calendar call. They have not brought this to trial yet. The state is still not ready. we're asking for a remedy, dismissal, whatever it may be. So, and the dismissal could mean dismissal, and the state can never bring those charges again because we got the whole double jeopardy thing. Anyway, so it's a little confusing with speedy, and I know it's kind of hard to understand. It kind of, I have to look it up every time. Okay, how many days again? And so I always have to look that up. So don't think as attorneys like we're this plethora of information, because we still have to look stuff up and we still have to research, and we still are dependent on Florida statutes and case law and all of that, because every case is unique. And I get clients all the time saying, well, my friend got arrested for that and this is all he got. Yeah, but your friend and your case are completely different. Everything is unique, everything is different. So it's really individual to you. So, hey, Stephanie, I like your picture. I like your little, I guess it's a pencil or something. What happened if someone is convicted and sentenced to death or life imprisonment, and then it turns out the person is innocent? Well, they have, I've heard, and this is just a side note, they have something called the Innocence Project, or there's other people that really work with people that say they're innocent and have evidence and all that, and they really work with them. And I really commend them, because a lot of times they do it free of charge, and really kind of it makes me feel good that there's people out there doing that. And so it makes me proud to be an attorney. But if it turns out that the person is innocent, there's a whole, I mean, that could be a whole nother live situation, where a whole nother live show. But they need to file motions for rehearings, retrials, rehearings, saying new evidence has been discovered, new evidence that was not discoverable at the time of the trial, all of those things. What we get a lot of times is witnesses recanting their stories. And that's really kind of difficult, because, okay, you were sworn to tell the truth, the whole truth, nothing but the truth. But now you're saying that you lied, and you're saying the truth now, how believable is that witness? So it's really a matter of filing motions for rehearings based on new evidence. Will the court allow that? If the court doesn't allow it, what kind of appellate, court can you get into? So it's really a long process to do that. If they are ultimately exonerated, and it was, because you see on the news, there have been cases like that, then they're released if they're found to be completely 100% innocent. And we've seen cases like that. I don't know personally of any cases like that. But it's unfortunate. Well, yeah, the what is it? The Central Park Five, those who they were convicted and served time in juvenile, and the one that served time in adult court, and then come years later to find out they never did it. And it was this one gentleman, and they were released. And, it's a sad situation that they had to go through that. But it's a very good question. And it is a long, long process to kind of get through the whole system and trying to get back in front of the judge to show them that. So good question, Stephanie. Thank you so much for asking that question. Okay, well, we're wrapping it up here. I thought today was going to be kind of a short little spurt, but, as per usual, I'm a talker, so I like to talk. Anyway, I want to thank everybody for coming. I don't know what the score of the game is. I haven't seen it. So as soon as we get off, I'm going to check that out. But I hope you all enjoyed me. And if you're watching the game, that you cheered for your favorite team. And I'm not going to probably talk to you. Well, I'm probably going to talk to you live after Christmas. So please, everybody, if you celebrate Christmas, Hanukkah, whatever you do, have a great holiday season. And I hope you're blessed.